I love being a public defender. When I went to law school, I told the Career Center that I wanted to be a prosecutor because I wanted to get the gangs. So I certainly wanted to be a prosecutor, or if I wasn't doing that, I needed to save the sea turtles. And it wasn't until my third year in law school that I had the opportunity to intern at the Wake County Public Defender's Office. And I loved going to the jail visits. I loved meeting people from all walks of life. I loved hearing their stories. And I loved seeing how our dedication and commitment really make a difference in the lives of the people that, that come across us. And I knew from that moment that I was not meant to be a prosecutor, but that we are meant to help the people. And it's a very important job that we do, and I wouldn't do anything else.
I remember the first day that I was able to stand in front of a jury and with just full, firm vigor say to the jury, I want you to find my client not guilty. I remember the case because I was appointed early on in it and was with the detectives the day they found the decedent's dead body in the woods. And it was a strange case to be out there when that happened. But I ended up conferring with my client, and the night that we did that, we made an offer to plead to a much lesser sentence, but to plead to a case of voluntary manslaughter. And the state rejected that. And we prepared for 3 years. And they declared the case to be capital. And we picked a jury and we tried that case. Never got to the sentencing phase because in the guilt-innocence phase, the jury convicted my client of exactly what we offered 3 years before. He was convicted of voluntary manslaughter and misdemeanor unauthorized use of a motor vehicle at a time when they could have stuck a needle in his arm and executed him. And he was sentenced to 5 years, already had 3 years and a couple of months credit. And that was a really proud time because I felt we had made an offer of what he was guilty of. The state wouldn't accept it, and the jury eventually found him guilty of exactly what we offered. I have seen that client since that case. He saw me on the street about 6 months ago and walked up and said he thanked me for everything that I did because his life would have been much different if we had not had the victory in that case that we got.
There are times when the court is unable to find out the truth without me being able to present our side of the argument or the case. And one of those cases happened when I had a client who was accused of assaulting a female. He had represented himself in district court and appealed the case. And so when we went to Superior Court, I was actually able to help him get documentations of where he was the night of the incident so that we could put on evidence to show an alibi that this couldn't have occurred because he actually wasn't there at the time. So that was a very rewarding event.
The community benefits, anytime that you can get a child that's involved in the system, that's never a good thing, clearly. But if you can get that child, even if they're less involvement in the system, studies show that they are less likely to re-offend or recidivate. And so if I can make the system have less of an impact on my client and the children that get involved in the system, then the community benefits from that.
I had a client who was charged with a crime, and by the time I had gotten his case, he had been held in custody 1,592 days and had only had 2 court dates, which he was never brought for, and no hearing date set, and was missing out on his family and seeing his children grow up and his elderly mother who needed him desperately. And I was able to get a rush hearing in on a speedy trial basis, and we were able to get him out within 2 days from that hearing date. So It was great to see his mother happy because I think they had lost all faith, and the ability to give them that hope again was a big moment for me.
It's because of the school to prison pipeline begins at the school, and it begins in juvenile court. And there's two areas where my kids are highly affected. They may be accused of being delinquent because of a crime that happened at school or outside of school. Routinely, they get long-term suspended for those offenses. Oftentimes, these kids have individual education plans because they have different types of disabilities, and the school may not have gone through the appropriate process for suspending these kids. The fortunate thing is, once they get to me, if they get to me in time, then I'm able to refer them out to an advocacy agency, the Advocates for Children's Services, who focus exclusively on advocating for students' rights. Because when I handle the criminal case, the juvenile case, that case may end up being dismissed. But that child would have already been long-term suspended, placed into an alternative learning program, which is going to be ultimately detrimental to their success in school. Secondly, North Carolina's High School Athletic Association, I believe that's the correct name of the acronym. Anyway, they have a policy that if a student is adjudicated or found guilty of a felony offense, they are unable to play high school sports. That is terrible when it comes to a 15-year-old or 14-year-old or 13-year-old or 12-year-old who, for whatever reason, gets adjudicated for a felony. They are no longer able to play high school sports, which may be the greatest deterrent from them getting into future criminal behavior. So oftentimes, whenever I have a kid who is accused of a felony, being able to either get those charges dismissed or reduced down to a misdemeanor so that they're not precluded from being able to play sports, which may be the only avenue they have for going to college or for even feeling good about themselves, we're able to give them that opportunity despite a bad choice they made or despite an unfortunate circumstance that found them erroneously in the system.
I'd say my proudest moment was involved with a client who was charged with a resist, delay, and obstruct an officer at a protest rally during the 2016 election campaign. There were a number of people that were arrested. My client was basically the first, and it caused this sort of cascade of people getting arrested. And she was convinced that she had done absolutely nothing wrong except to voice her displeasure at a certain presidential candidate. She maintained to me the entire time that she had done nothing wrong and was just exercising her First Amendment rights of both protest and assembly. We looked together at about 15 hours of body-worn camera footage from that day to find my client, see what she had done, and as we found, she was completely doing nothing wrong. She was had a sign, was protesting almost silently, if not quietly, and absolutely doing her constitutional right to protest that she wanted to. And we presented all of that evidence, edited with timestamps, showing all the places where my client was doing everything correct, and that it was a police overreach, and her First Amendment rights had been violated. And through that work and working with the client, which was the most engaging and rewarding part about it, we were able to get her case dismissed after a long period of time and some press coverage and through my client's real hard work in identifying what she had seen and helping me in the process. That's what it's all about. I mean, you get to protect someone's First Amendment rights. That's a dream when you're in law school, and it's a dream when you become a lawyer. So it was really exciting that I got to do that.
There was one afternoon that I was in district court where a client of mine that I've had on multiple low-level charges that came from his homelessness. So second-degree trespass, impeding traffic, soliciting alms, stuff like that. We'd been working with him for a while, and he'd been on the wait list for a placement at one of the local shelters where they were actually able to give him an apartment. And I'd been working with his caseworker, and he had just a few charges left still pending. So he came to court, and he'd been placed, and he'd gotten his own place finally. And while we were in court, we realized that there was still an unserved warrant for a charge that was pending. And unfortunately, because it was a charge that hadn't made its way to court yet, there was no way we could address it. So the deputies came in and prepared to arrest my client. And I said, okay, well, that's fine, but the magistrate who looks at his bond or looks at assigning his bond is not going to know all of these things about him. That he's, finally got his own place, that he's been coming to court consistently, that we've been able to get everything else dismissed. That person is only going to see his record and his record of failing to appear in court before. And so, I went down with them and spent a few hours in waiting at the jail before we could get in front of the magistrate together so that I could tell them, listen, I understand what his record shows. I understand what, how many times he's missed to come to court, but so much has changed in the last month that none of that is reflected in the documents. None of that is reflected in what you're going to see, and so I need to tell you that. And the magistrate heard that and gave him an unsecured bond. And he was able to come back to court, get those charges dismissed, still keep on track with all of his substance abuse and mental health treatment and everything, and thankfully stop from potentially getting rearrested, losing his placement if he couldn't go back, and keeping him on the right track.